The privileges of Parliament, the lower part, the lower paragraph. The privileges of Parliament are likewise very large and indefinite, which has occasioned an observation that the principal privilege of Parliament consisted in this, that its privileges were not certainly known to anyone but Parliament itself. And therefore, when in 31, Henry VI, the House of Lords propounded a question to the judges touching the privileges of Parliament, the Chief Justice, in the name of his brethren, declared that they ought not to make an answer to that question, for it has not been used aforetime that the judges should in any wise determine the privileges of the High Court of Parliament, for it is so high and mighty in its nature, that it may make law, and that which is law, it may make no law, and the determination and knowledge of that privilege belongs to the Lords of Parliament and not to the justices. Privilege of Parliament was principally established in order to protect its members not only from being molested by their fellow subjects, but also more especially from being oppressed by the power of the crown. It therefore, all the privileges of Parliament were once to be set down and ascertained, and no privilege to be allowed. But what was so defined and determined, it were easy for the executive power to devise some new case, not within the line of privilege, and under pretense thereof to harass any refractory member and violate the freedom of Parliament. Therefore, the central thought which I wish to emphasize, based on the historical origin of privilege, is criminal law is one aspect of the public good, of public policy, but the independence of members of the Parliament from the crown, and in a democracy substitute it with a democratic executive, it is equally an important factor. And that is where I'll place that relevant passage from Justice Bharucha's judgment. Now, page number 808. Can I read, Madhya?
Yes.
Broadly interpreted, as we think it should be, Article 1052 protects a member of Parliament against proceedings in court that relate to or concern or have a connection or nexus with anything said or a vote given by him in Parliament. The charges against the alleged bribe takers is that they were party to a criminal conspiracy and agreed to or entered into an agreement with the alleged bribe givers to defeat the no confidence motion by illegal means, namely to obtain or agree to obtain gratification other than legal remuneration from the alleged bribe givers as a motive or reward for defeating the no confidence motion, and in pursuance thereof, the alleged bribe givers passed on several lakhs of rupees to the alleged bribe takers, which amounts were accepted by them. The stated object of the alleged conspiracy and agreement is to defeat the no confidence motion, and the alleged bribe takers are said to have received monies as a motive or reward for defeating it. The nexus between the alleged conspiracy and bribe and the no confidence motion is explicit. The charge is that the alleged bribe takers received the bribes to secure the defeat of the no confidence motion. While it is true that the charge against them does not refer to the votes that the alleged bribe takers, Ajit Singh excluded, actually cast against the no confidence motion, and that it may be established he hoarded those votes, as the Attorney General argued, we do not think we can ignore the fact that the votes were cast, and if the facts alleged against the bribe takers are true, then they were cast pursuant to the alleged conspiracy and agreement. It must then follow, given the expression in respect of must receive a broad meaning, that the alleged conspiracy and agreement had a nexus and were in respect of those votes, and that the proposed inquiry in the criminal proceedings is in regard to the motivation thereof. It is difficult, but this paragraph is important, in the context of Blackstone as well. It is difficult to agree with the learned Attorney General that though the words in respect of must receive a broad meaning, the protection under Article 1052 is limited to court proceedings that impugn the speech that is given or the vote that is cast or arises thereout, or that the object of the protection would be fully satisfied thereby. The object of the protection is to enable members to speak their mind in Parliament and vote in the same way, freed of the fear of being made answerable on that account in a court of law. It is not enough that members should be protected against civil action and criminal proceedings, the cause of action of which is their speech or their vote. To enable members to participate fearlessly in parliamentary debates, members need the wider protection of immunity against all civil and criminal proceedings that bear a nexus to their speech or vote. It is for this reason that a member is not liable to any proceedings in any court in respect of anything said or any vote given by him. Article 105 does not say what it would have if the learned Attorney General were right, that a member is not liable for what he has said or how he has voted. It would have then been worded differently. While imputing, this is important, minutes. I'm linking this to what Blackstone said then, minutes. While imputing no such motive to the present prosecution, it is not difficult to envisage a member who has made a speech or cast a vote that is not to the liking of the powers that be, being troubled by a prosecution alleging that he has been party to an agreement and conspiracy to achieve a certain result in Parliament, has been paid, achieve a result in Parliament and had been paid a bribe. Therefore, minutes, a powerful executive, whatever be the ruling party, minutes, it's a fact of political life in India today, minutes, that the law is misused. So this is an equally important consideration. If a member is to vote fearlessly, he should be free from the fear of prosecution. And therefore, it is not just, milords, an immunity from criminal law. Yes, sir. We are acutely conscious of the seriousness of the offense that the alleged bribe takers are said to have committed. If true, they bartered a most solemn trust committed to them by those they represented. By reason of the lucre that they received, they enabled a government to survive. But so, they are entitled to the protection that the Constitution plainly affords them. Our sense of indignation should not lead us to construe the Constitution narrowly, impairing the guarantee to effective parliamentary participation and debate. So the majority was equally anguished, milords. This is not an amoral judgment. The majority would have been as shocked as any court would have been, as any conscientious citizen would have been, milords. But the majority said we must read the Constitution as it is written. And there is reason for it. Members need protection. And then, milords, as far as criminal prosecution is concerned, you can't differentiate between corruption and defamation. If there is protection from criminal prosecution, it has to be in all respects, milords. As long as it bears a nexus. In Ajit's case, milords, this honorable court sufficiently refined it, milords, in the recent Kerala Assembly case. If a member commits an act of vandalism, or, milords, take an extreme case of a physical assault, then it is obviously not protected, because by no standard can it be said to have a nexus, milords. Similarly, that test may perhaps conceivably be applied to a hate speech situation on the floor of the House also, milords, as to whether it had any nexus at all with the role of the member in the performance of his duties. But, milords, once that immunity is there, then we can't, milords, dissect it and say corruption shocks us, defamation is of a different character, defamation is more political in character. It has to be absolute protection, milords. And therefore, milords, this anguished conclusion of the majority bearing in mind what weighed with the constitution makers, bearing in mind the historical background of privilege, is not even 25 years later something which would shock the conscience of this court, minutes. To repeat, minutes, political corruption is a fact of modern political life and, minutes, perhaps historical and ancient political life also, minutes.